Okay, everybody, thanks for tuning in. Any particular questions that's come up for you this week that we want to address before I cover my topics? No confusion among us? I know I'm confused. There's a lot going on. I'm going to start with these buyer and seller advisories that were in the practice tip. We're going to see a lot of changes and upping our game around confirming that we've notified buyers and sellers about the negotiability of commissions and that we're going to. In fact, I was in the board meeting here at Bayris this morning, and probably in January or February, there's going to be a new drop-down button that listing agents, when you're entering a listing, you'll confirm that it'll be a yes or no box. But the question or the statement will be that you're confirming that you've notified the seller that listing fees are negotiable. And then you'll check yes or no. But it's just another step along the way to confirm that we're having these transparent discussions with both buyers and sellers about commissions. So the advisory last week, and I'm see if I can pull this up. That's not the one I want. That's the one I want. Oops. Well, there is the advisory. Let's see if I can find it here. There it is, broker risk management. Can we all see this thing here? The broker risk management form. It says NAR litigation and the use of the buyer and seller advisories. So this is an explanation about what the litigation does, that we shouldn't be particularly concerned about it. The practice tips.
Gary, I don't think we're seeing it.
Okay, let me stop and start again. Thank you. If I start talking about something that you're not seeing, just let me know. Okay, can you see practice tips now?
Yes.
Okay,
yes.
Thanks. So all agents, whether representing buyers or must fully disclose all commissions and payments made to agents representing clients in the sale. Listing agents should explain to sellers their options and potential impacts of those decisions on the sale of the property, as the seller's choices may affect the sale of the property, how the market will react to the seller's decision, as explained above. It is recommended that after explaining the seller's options, a listing agent have a seller sign the attached seller advisory, which documents that they had this discussion with the seller. Buyer, this is a practice tip. Buyers agents should consider using buyer broker agreements with all buyers. I was speaking to a CAR director on last week, or actually I think it was yesterday, and it's very likely CAR is going to introduce legislation in the California legislature this coming year in 2024 that would require all of us as brokers and agents to have buyer broker agreements with our buyers. So this is a form we just got to get used to, and we've gone over in the past, that the CAR website has a variety of classes and training on using the buyer broker agreement. So if you haven't filled one out, take one out, fill it out, and let us know if you have any questions. But CAR recommends this form, and I think I know our attorneys are recommending this form. It's very likely we will require this form as a brokerage, and it's very likely we'll be required to do it as a matter of law, just like we're required to do the agency disclosure and the transfer disclosure statement. Number 4 here is buyer's agents should fully explain to buyers the payment of a commission in any particular transaction and document that discussion using the buyer commission advisory, which I'll show you in a minute. And then transparency in the payment of fees is a priority and must be fully disclosed to buyers and sellers. Okay, any questions about any of that? Okay. I'm just curious, how many of you have, you can raise your hand, you know, either physically or in your little raise the hand box. How many of you actually have used the buyer broker agreement with your buyers? Eric has, I know, we've just talked about that. All right. Well, it's going to be a practice, so we should practice it. So next time you have a buyer, fill out the form. If you don't know how to explain it, we have lots of guidance on how to explain it and use it. Okay, that's the advice we got. Okay, I'm going to try another form here. See if this will come up. This is the buyer advisory, and this was part of the practice tip. Can you see this? It says buyer advisory regarding real estate broker compensation.
Yes.
Okay, thank you. And this is a notice, and it's we put our brokerage name in here, and then you fill out the form. The amount of the rate of the real estate commissions is not fixed by law, blah, 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 blah. Seller's agent's compensation. Sellers typically have an exclusive listing agreement with a seller's agent, and seller's agents are paid by the seller upon close of escrow. Sellers may choose to offer a buyer's agent compensation through the MLS, but have no legal obligation to do so. The amount that the seller's agent is offering a buyer agent through the MLS is displayed and available to you and your buyer agent. Buyer's agent compensation. And so it says, historically, buyer agents were paid by the seller through a seller's agent offer of cooperating broker compensation through the MLS. The sellers pay the seller's agent, and the seller's agent shares that commission with the buyer's agent as specified in the MLS. While this is still a common practice because of recent litigation and changes in MLS rules, sellers may decline to pay buyer's agents. Either the seller will pay the buyer's agent or the buyer will pay their agent. Currently, a seller may pay compensation which is acceptable to the buyer's agent to represent you. Pay the buyer's agent nothing, or offer to pay some other amount. When you begin working with an agent to represent you in your purchase of real estate property, that agent may ask you to sign a buyer representation agreement, BRBC. That agreement will set forth the terms of your relationship with the agent. Read that agreement carefully. And then it goes on to explain how all that works. So I'll attach this advisory again when I send out the recording, in case you can't find it in your prior emails. But that's what we use with our buyers. Okay. And then there is go back here and share. There's a similar form for our sellers. Can we see that now? Seller advisory regarding real estate broker commission compensation. Someone say yes or no. I've lost you all. Well, I'm assuming you can see this.
I can see.
Oh, thank you, Ann. So this is a seller advisory. So similar language, talks about how the buyers and sellers, what the seller can or cannot pay, how the buyer's agent can or cannot be compensated, and so forth and so on. So read these forms, get used to them, and use them. It's all designed to save us from lawsuits. So, and though we should be certain that none of these lawsuits so far, and there's many of them now throughout the country, are directed towards individual agents. They're directed towards the larger brokerages, the associations of realtors, some MLSs, so forth and so on.
Barrett, I had a question.
Yes.
So when you're representing a seller at this point, the only thing you would need to add would be the seller advisory regarding the buyer broker.
Yes.
And then from the buyer's side, you have to do both a buyer
Yeah,
agreement
correct.
and the advisory. Got it.
Yes.
Thank you.
Yep. Good. Any other questions on those forms? Yes, Steve, you got your hand up. Go ahead.
Yeah, a co-realtor of ours up here at Bingtree, who I'm close with, she is representing the sellers, and she got an offer on the property, and the offer included the buyer broker agreement with the buyer's agent, stating that the buyer was willing to pay the commission. So she called me. She says, "Does this mean that my sellers don't have to pay the buyer's agent's commission?" I said, "I don't believe so. I believe whatever's printed in the MLS supersedes that." I said, "But you should check with Larry just to make sure."
Yeah.
And so she checked with Larry, and that's what Larry confirmed as well. That is true, correct?
Yes, Steve, that was good counsel. Let's say we have a buyer broker agreement with our buyer, and it says that the buy, we're going to be compensated 2.5%. That form also says, as we've gone over in the past, that if the seller is offering to pay the buyer's agent a fee through the MLS or otherwise, that fee part that we're getting, the buyer's agent is getting from the seller, will be offset what the buyer owes us in that buyer representation agreement. So the buyer, there's an advisory about this at the CAR, and we don't want to use the term that the buyer is paying nothing, but because the buyer, without the buyer paying the purchase price to the seller wouldn't be paying the buyer's agent, right? So what we would say is that the buyer doesn't have to come out of pocket directly to pay that fee, because the seller is going to be paying on the buyer, on the buyer's behalf, basically. Yeah, Steve.
So do you recommend, if we're representing a buyer, that we include that BRBC with our offer?
Only, well, yes, there's a requirement if the seller is going to be paying the fee that well, let me look at the RPA, because the RPA addresses that, and I'll be pulling up the RPA in a minute. But I wouldn't, I'm not sure that as a matter of course I would attach the buyer broker agreement, but that's addressed in the RPA. So let's look at that, okay? Let me find that. Okay.
Gary, a related question.
Yes.
If the seller is offering 2.5% and the buyer broker contract is at 3%, then I assume the buyer owes their broker 0.5% in that scenario.
Repeat that again.
If the seller is offering 2.5% to the buyer's broker and the buyer broker agreement is at 3%, then the buyer would owe his broker 0.5%.
Yes, that's the way that that form reads. Now, whether we enforce that or not, this is not coming up properly, so I'm going to start again. All right, I got to get out of that. We have the option as the broker to accept the amount that's being offered in the MLS and not enforce the extra 0.5%, though the form itself reads that the buyer will pay us that extra 0.5%. So let's get to the RPA and deal with that.
Hey, I have one quick thing I can add because I trained extensively on this form with John Stopkowitz about a
Yes.
week ago.
Yeah.
And so there's actually a really important box to check. Let me actually get that paperwork. I have it right here with all these notes on it. Like I took notes, like basically I printed out the whole contract and then took notes right on it. So okay, so it's section D, item 3, authorization to include commission in offer.
Yeah.
Buyer authorizes, and then there's a little box in parentheses, does not authorize. So you basically want to make sure that you don't check that box, because the buyer authorizes broker to include a term in the buyer's offer obligating seller to pay broker directly or through escrow for any compensation that the buyer owes the broker. So what this means is if the buyer authorizes the broker to include this term, then what would happen in that situation where there was 3% in the BRBC agreement and only 2.5% coming from the MLS, we could actually, in the contract, ask the seller to pay that extra 0.5%. So what would happen is that the seller could say, no, I don't want to, but we can include it in the contract to require it as like a contingency. And so then that would mean at the end of the day that you might be making 3%, and then the selling broker, he negotiated his contract for 2.5%, so he would only get 2.5%, and you could get paid more if that was the agreement. And it looks as if you can ask the seller to pay for that. It doesn't automatically parlay onto the buyer if that box is unchecked.
Yeah, let's go to that paragraph in the RPA. What was the number again?
It was D3.
C3, right.
D3. D is in David.
Right. D3?
On the buyer representation and
Oh,
broker
okay.
compensation
Right,
agreement.
right. I'm looking at the RPA here and where it
Okay.
gives it. Okay,
Got it. But the guy's question had to do with the BRBC.
right.
And so I was
well,
basically answering that question because no, it doesn't necessarily get put on the buyer. It depends on how you guys fill out this form. So that's very important.
And when you're preparing your offer for the buyer, let's say you have a buyer broker agreement, and you get to this section I'm highlighting now, the G3 in the RPA. This is the RPA, and we're grid part G3. And it says seller agrees to pay the obligation of buyer to compensate buyer's broker under a separate agreement, CAR form SBPP. Seller's broker offer, if any, to compensate buyer brokers is unaffected unless otherwise agreed. So if you had a buyer broker agreement and you encountered an offer of compensation through the MLS that was either less than, or, let's say it was 0, that the seller was not offering any compensation through the MLS, yet you wanted your offer to include compensation to you as the buyer's agent, or, the buyer doesn't want to pay it separately, they want the seller to pay it, then you would check this box G3. And the seller agrees to pay the obligation of the broker as part of a separate agreement, and you would attach the SPBB form. That's a seller's payment to the buyer's broker. Seller payment, buyer's broker.
But Garrett, you wouldn't need to do that if there is,
if there's
a
an offer of
compensation posted. Yeah.
So in answer to Steve's question,
Yeah.
Let's say you were asking for that extra 0.5%. That was the difference, as Eric pointed out, between the offer in the MLS and what the buyer has agreed to pay. And you wanted the seller to pay that extra amount. you would check this box and your SPPP would have a 0.5% in it. If the seller was offering nothing, then the buyer wanted the seller to pay the commission because they wanted to use their cash for down payment or improvements of the home or something. They didn't want to pay it out of pocket. They wanted it included in the sales price. Then you would check this box and the SPP would put, whatever fee it is you've agreed to with the buyer, 2.5 or 3 or whatever it is. That's when you would check this box. Okay. Yeah.
Got it.
Steve.
So the answer to my question is you would include the BRBC and the SPBB
Correct.
on with the RPA.
Yes. In that case, you would.
Okay.
Yeah. But if you have a buyer broker's agreement and the offer in the MLS is the same as the buyer's broker agreement, there's no need to attach it at that point. It would only be if it's your buyer broker agreement is different than the offer of compensation in the MLS. Does that make sense?
Yep.
Okay.
Yes, that makes sense.
Okay. Yeah, well, this is why I said this is all confusing stuff. It's all new to us, and we're just we'll learn in time, as your colleague did there, Steve, about how we deal with these things. But I wouldn't attach the buyer broker agreement unless you were checking that box G3 and there was going to be a difference in the amounts asked for and offered. I hope that's clear. Okay. Let me cover a couple of things that came up this week. We have a listing. No, I take it back. We're representing a buyer and there were 4 signatures on the buyer's side. I don't know, family was buying it or something. Anyway, there's 4 signers on the buyer's side. So, of course, the contract itself, the RPA has room for 2 signatures, but we needed to add the ASA form, which is the additional signature addendum, which would list then the other 2 signatures. Now, so that we didn't have to get all 4 signatures on all the documents, there's a part of the ASA that says the parties acknowledge that they have received all of this documentation. And what our TC did was make a long list, about 25 items, that the initial buyer had already signed. And we have the list of the documents, the date of the document, and the number of the pages of the document on that form. And then by attaching it to the ASA, those additional signers are acknowledging receipt of all those forms. So that was an acceptable way to do that, where we didn't have to go get, 4 signatures on every single document. So that was just a kind of a structural thing when you have more than one signature required. Same thing would happen if you are adding a buyer during the course of a transaction, which happens sometimes. You add a co-signer or something like that, and you would use that same kind of format of adding the additional forms, a list of them, their page numbers and their dates, and that would be part of what the new buyer is acknowledging. Okay. Any questions on that? Yeah. Yvonne?
Yeah. So you have the ASA form, but what are you actually using to list the documents?
We create that ourselves. The TC created that.
Okay, so it's just something, and then you go attached is blah, blah, blah. Okay.
Correct.
And it's a date and name and pages?
Yes, number of
Okay,
pages.
great. Yeah, I've struggled with that form in the past.
Yeah. Steve?
Yeah, I came across this exact same scenario that you described. And I found out that when you're making out the cover sheet of your transaction, at the very top, there is a parties, Parties, And if you
Yes.
click on that parties and then you go and you scroll all the way down on the left-hand side, you can add as many people as you want. And it could either be the seller side or the buyer side. And you
Right.
can put in their email addresses. And
Mhm.
so what it did was it auto-populated to all of my documents because these people were all over the country.
Mhm.
And I was able to get each of their initials or signatures on all the documents, and it was very smooth and very easy because their email addresses were all plugged into that cover sheet. So it made it quite simple.
Yeah. So Steve's talking about the cover sheet for your transaction in the ZipForms. And it's a good form, you know, it's good, and we used to have we had some training on that about using that form, filling out those profiles. And Steve's correct. I mean, it would be preferable if we had each party's signatures on each document. And Steve did that properly. In some cases, you know, we haven't done that, and we're trying to backfill with the acknowledgements that the parties acknowledge receipt of the documents, and we use this other method I described. Okay. Katie, our lead TC, is very familiar with this, and Keely probably as well. If you have questions, ask your TC. They'll ask me if you know how best to handle, and we'll get it done. But Steve's approach is as he said, pretty seamless if you add those parties and their email addresses along the way. Okay. Another thing that came up this week is we represented a landlord who owned a condominium, and they wanted to rent it out to a party. And one of our agents who does property management for us, and we don't recommend you do property management unless you have, you know, direct experience in that. You know, call us if you want to kind of do that. But he does that as a practice, and that's fine. So he arranged for this tenant. They went through the application process, and it was going to be a mother and a daughter moving into the place, and filled out the application. Everything looked fine. They signed the agreement. She paid a deposit. The lease is not going to be effective till March 5th. I'm sorry, December 15th. Now, in the meantime, our agent gets, our agent was not representing the tenant, and properly had a non-agency form signed with the tenant, indicating that the tenant, he was not representing the tenant, he was just representing the landlord. Now, you know, like this week, he gets a phone call from a realtor unassociated with this transaction, but who he knows, and who knows the applicant tenant. And the short of it was that the applicant tenant has been living in another rental, and her boyfriend was living there with her on a part-time basis. Well, the boyfriend is this is the phone call says, we don't know this, but in this phone call, the party described that the boyfriend is a sex offender, and has a restraining order against seeing another party's child, you know, his child. No, not his child, but another party's child, where he had been involved with sexual abuse. So this is all being told to us, you know, and that this phone call party says that the woman plans that he will move in with her and her daughter, And so, you know, she's kind of given us writing this kind of bad scenario out. So what do we do with that information? Well, I've used this term in the past, and it's borrowed from our broker risk management folks, and it's the acronym DAD, D-A-D. We disclose, we attribute, and we disclaim. And actually, we can add another A at the end, advise, and then we devise. So it's DADA. So we disclose, and we write a report about the phone call. And we actually, after our agent wrote up this report, we sent it to legal counsel to kind of say, is this what we should send? And they said yes, but eliminate any commentary. Just make it factual and sterile about what we were told. So we cleaned that up a little bit. So we write a factual and sterile report about the disclosure we heard from the neighbor or from a phone call or from wherever we get this information. We have to disclose it. So we disclose it. Then we attribute to it. So attribute it means, where did you get this information? Well, we got it from this phone call, this person on the phone call. So that's the attribute part. So actually the attribution in this case, we started the letter saying, we got a phone call from so-and-so, a realtor in town, you know, who said this. So we attribute it. And then we disclaim it. So after we've described it and attributed it, we disclaim it. We say, we don't know anything more about this, and we're not going to investigate. Okay, we disclaim knowing anything more about it, and we say we aren't going to go, you know, we aren't going to investigate this. Just as we do on our emails, it says information from third parties is not verified, or whatever that we say in the bottom of our emails. And then the last thing is we advise them to speak to a qualified California real estate attorney, the old QURCA, California Qualified Real Estate Attorney. And in this case, because it's a rental property, we say a California qualified real estate attorney, qualified California real estate attorney who practices landlord-tenant law. Because you might have an attorney who practices transaction law, but they don't do rental landlord-tenant relationships. So we add that little bit. So this could happen on a listing. In this case, it happened on a lease. Sometimes we just get third-party information, and we got to use the data approach. So if you get that in your transaction, you know, let me know about it. Let your manager know about it, and we'll follow those steps. And if it's a case like this, we will run it by our legal counsel for review before we give it to our client. Okay. Any questions there? All right. How are we doing time-wise here? Okay. So I recently took a course on the RPA itself. And I didn't realize this, but there are 67 ancillary forms, as they call them, that are referenced in the RPA. So, you know, here they're referencing some here in this area, and then paragraph 4A, B, C. So there's the TOPA, the PAPA, the MHA PA, the TIC PA, the co-op PA. Well, in total, there are 67 references to ancillary forms in this RPA. So essentially, not only, I mean, if we're checking any of these boxes, say the TOPA form, we got to understand what that TOPA form is, as well as understand the RPA. So we shouldn't, you know, we kind of need to do our research here and understand these things. But I was amazed that I would have never thought there was that many ancillary forms referenced in the base RPA agreement. I wanted to go over this course, also spent a fair amount of time on paragraph 25. And, because, the business points in the transaction are all covered in the grid now. So we may feel we fill out the grid and we go down to the signature line. That's the expedient way to do that. But we're really charged with understanding all the paragraphs in this agreement. And that includes this paragraph 25, which is definitions and instructions. The following words are defined terms in this agreement and shall be indicated by initial capital letters throughout the agreement and have the following meaning whenever used. So there's acceptance, there's agent, there's agreements, as is. As is conditioned, the seller shall disclose known material facts and defects as specified in this agreement. The buyer has the right to inspect the property and within the time specified, request the seller make repairs or take other corrective actions or exercise any contingency cancellation rights in this agreement. The seller is only required to make repairs specified in the agreement or as otherwise agreed. So the property is being, often the seller says, I want to sell the property as is. They get an offer and they say, well, I want to make sure this is as is. Well, the contract is as is. But the buyer has the right to inspect and the buyer has the right to request repairs. So that's, and if the seller agrees to repairs or a credit, then it's not as is. But the base contract is as is. Counting days. This is a rather large paragraph here. It's 25I. And it's done as follows, unless otherwise agreed. The first day after an event is the first full calendar day following the event and ending at 11:59. For example, if the notice to a buyer to perform is delivered at 3 p.m. on the 7th calendar day of the month, or acceptance of a counteroffer is personally received at 12 noon on the 7th calendar day of the month, and the 7th day is 0 for purposes of counting days. To respond to that MPB or calculating the close of escrow date or contingency dates, and the 8th of the month is day 1. Now your TCs know this, and when they do your form, your timeline, they'll be counting days properly. But you should understand this too, because your buyer will want to know when their contingencies are up. Your seller will want to know when the contingency releases are due and all those good things. And number 2 here, all calendar days are counted in establishing the first day after an event. So we count all the days. There's only one case in which business days are counted, and we'll get to that in a minute. 3, all calendar days are counted to determining the date upon which performance must be completed, ending at 11:59 p.m. on the last day for performance. That's the scheduled performance day. So technically, if your buyer were holding off on removing contingencies, they got till midnight or 11:59 to do it. They can slide it in there like a eBay bid, a late bid. Try to fake the seller out, or I don't know why you would do that, but that's how it's defined here. After acceptance, if the scheduled performance day for any act required by this agreement, including the close of escrow, lands on a Saturday, Sunday, or legal holiday, the performing party shall be allowed to perform on the next day that is not a Saturday, Sunday, or legal holiday, the allowable for performance day. So we have the performance day, and then we have the scheduled performance day, and then we have the allowable performance day, ending at 11:59. And this was actually added in the last generation of the forms. A legal holiday shall mean the holiday or optional bank holiday under civil code, blah, 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 because it didn't used to be defined. It was just, it just said holiday. But now it's a legal holiday as defined in the civil code. 5, for the purposes of the CO day, any day that the recorder's office in the county where the property is located is closed, or any day that the lender or escrow holder under this agreement is closed, the close of escrow shall occur on the next day the recorder's office in that county, the lender or the escrow holder is open. So that may not be a legal holiday. It may be a special bank holiday or something. But if it's closed, we can't, if the institution is closed, the recorder is closed, like the recorder is going to close over the holidays sometimes, right? They close between December 25th and January 1st. Well, we can't close them, and it gets pushed over until they're open again. And that's a legal definition in the contract. COE, close of escrow, is considered day 0 for the purposes of counting days seller is allowed to remain in possession if permitted by this agreement. So if you have a 10-day, 15-day, let's say you have a 15-day seller right to occupy. Well, it doesn't start the day of closing. That's day 0. It starts the day after. When you're counting those. So that's a lot, but it's how we properly count the days. And the next definition is day or days means calendar days or days. However, delivery of the deposit to escrow is based on business days. So, the RPA says that the deposit shall be deposited within 3 days after acceptance. And of course, remember, acceptance is delivery. It's not when it's signed, but when it's delivered. And, delivery here, we'll get into that in a second. But the deposit is the only one that's based only on business days. So if you acceptance was deemed to be a Thursday, you'd have Thursday, Friday, and Monday. Assuming they're all business days, you could have until Monday to put your deposit in. Okay. Delivered, or delivery definition. Unless otherwise agreed, means and shall be effective upon personal receipt of the document by the buyer or the seller or their authorized agent. Personal receipt means a copy of the document or an applicable link to the document is in possession of the party or authorized agent regardless of the delivery method used, i.e., email, text, or other. An electronic copy of the document, or as applicable, a link to the document has been sent to the designated electronic delivery address as specified in the real estate broker section on page 16. We'll cover that in just a second. After acceptance, the agent may change the designated electronic delivery address for that agent by, in writing, delivering notice of the change in that electronic delivery address, the EDA, as they call it. Links could be, for example, to Dropbox or Google Drive or other functionally equivalent programs. If the recipient of a link is unable or unwilling to open the link or download the documents or otherwise delivery of the documents directly, recipient of the link shall notify the sender in writing within 3 days after the delivery of the link. And you would use an RFR form. It's one of those ancillary forms. In such case, delivery shall be effective upon delivery of the documents and not the link. I don't know. I've never really seen a link used in transactions, but I guess that's possible. Keely, you ever get documents in the form of a link?
Yeah, actually, I do a lot.
Okay. Well, if the other party receiving that link, as they say, it's an agent who doesn't have a Dropbox account or something, then they need to notify the other party who sent the link that, hey, I can't open this link, and it's not effective until you actually send them a PDF or otherwise get them a copy. Now, this is funny because we referenced otherwise agreed several times here. It says unless otherwise agreed. Well, they define otherwise agreed here, 25.0. Otherwise agreed means an agreement in writing, signed by both parties and delivered to each. So you can't have a casual otherwise agreement. Anything that is going to change the base terms of the contract here means that the parties otherwise agree has to be in writing. So your verbal agreement, the parties agree, oh yeah, the seller can stay on for 10 days or whatever, isn't valid until it's in writing. Now, so we referenced this real estate broker section. And this box down here, designated electronic delivery addresses. So this is for the buyer's broker, and you would check the box email, text, or alternative. And for the seller's broker, you would check email, text, or alternative. If nothing is checked, then you don't have a valid electronic delivery address. So keep an eye out for that. If you're filling out this form, make sure these boxes are, if you're preparing it as a buyer's agent, make sure these boxes are checked. I guess, I would use email typically, but you could use a text, and that is the official form for electronic delivery. All right, I'm going to stop there because that was a lot of stuff. Steve, you have a question?
Yeah, when you send an RPA over to a seller's agent, you're representing the buyer, and the expiration of offer is 72 hours after day 0, of course. Weekends and holidays do not take effect. Is that correct? Because you do not have an accepted offer as of yet.
No, those are 3 calendar days.
Correct.
Yep. No, doesn't matter weekends, or holidays, you count them in that case.
That's what I thought. I've had sellers in the past, sellers agents saying, well, the 3 days fell on a weekend or a holiday, so we won't be getting back to you until the next business day. I go, I don't think that's how the contract reads.
Yeah, so where you would point them to is that paragraph in the definitions, says counting days. Okay. Any other questions on those things? There's just a lot of minute detail in these contracts when you really get into them. And again, as a standard of practice, we're charged with understanding them all. So it doesn't hurt us from time to time to go back and review all the paragraphs in the documents we're using. There are 2 other things I wanted to look at. Let's see. There's a library of CAR sample letters. So here you are, I'm in the documents section of my file, my folder. These are all my documents. And these are all the other forms. When I need to add another form, I go to, the form and I choose it and it gets added to my library. There is this thing called CAR sample letters. So I'm up here in the selected library. So there's a library of CAR sample letters. And look at all these letters they've got. abandoned property, personal property that's left on the, there's a letter about notifying that the resident of that. Access to premises letter, acknowledgement of non-tenancy, acting against the broker advised letter for a buyer and for a seller. Belief of abandonment for commercial property and residential property. So if you have a situation where you're needing to advise the one or another client or a tenant or somebody about something, I would check out this library and then see if the letter that is recommended is appropriate. So check with us, your manager or me, but become familiar with these letters too. So this one was for risk of failure to close, a breach of contract. So there's a notice here to agent, right? And then the letter, specific instructions. This letter is for a listing agent to give to a seller. It's for the situation where a seller is refusing to transfer the property in breach of the contract. The letter warns the seller of various legal risks that he is facing. Now, remember, we don't determine when either a buyer or seller is in breach. So this is a little forward thinking about that. We know what a breach is, because breach of contract is a legal term. But, once in a while we run into a seller and says, no, I don't want to close. I don't want to sell it. And this letter could be sent to that seller, just advising them of the risks. The buyer may have the right to sue you for damages. It may include compensatory and consequential damages, loss of profits, damages for delay in conveyance. These are all crafted by attorneys, CAR attorneys, and they're for our use. So it's good to know they're there. And there's a lot of them. So if you ever have the situation where you're looking and notifying your client or the other agent of something, and you want to do it in some kind of an official form, look up those sample letters, see if there's ones that are applicable. And if you call us and say, well, what should I send them? We'll look up those letters together and see if there's something applicable that we can use. And if it's a legal situation, we'll run it by our legal counsel. But those letters are there for our reference and our use. So I wasn't even aware of that they had that big library. Anyone ever use those library letters? I'm not seeing anyone agree. So, but that's part of the tools we have. There's a lot of them out there. There's one more thing I'll cover, and then we'll call it a day. See if I can get back to, I may not be able to get back to CAR from here. Oh, here's that list of ancillary forms. Let's see if I can share that. One second. So these are the ancillary forms that are all covered in the RPA. The purchase agreement forms, new forms, related forms, revised forms, and this is as of 10/22, I think, or 12/22, I think. But all these forms are referenced in the RPA. And as I say, in the standard of practice, if we're selecting one or another of these forms and they're applicable to the transaction, we're supposed to know what they mean. Anyway, there's a consumer's guide to the RPA available, and it has to be purchased. So let me see if I can find that. No, that's not what I want. Hold on a second. So I'm going to go back to the CAR homepage. Okay. Okay, CAR home page. Okay. Now, if we go over to the shopping cart, and we've talked about the shopping cart, wants me to log in again. And there's this free buyer representation forms course. Usually costs $30 or something. They're offering it free. So if you have any questions about the buyer representation forms, using the buyer representation forms, you can sign up for this free course. All you got to do is hit on the shopping cart, and this comes up front and center. Now, the one I'm looking for is called Consumer Guide. So you can see this Consumer Guide to the Residential Purchase Agreement. This costs $19, I think. It's discounted from $39. But if you have questions, or you just want to study up on the RPA and how it works for buyers and sellers, and what is explained from a legal point of view to them in understanding the RPA, I'd get one of these. And maybe you even want to give it to your potential client, who's going to be filling out the RPA, or a seller who's going to be filling out the RPA. And that would be not a bad step to get them up to date and up to speed on the 16-page contract that they're expected to understand and agree to. So that's where you find that. Okay, well, any questions? Took the full hour today.
I have a question.
Yeah, sure, Jennifer.
Are there resources where forms like that or guides are translated? Because we're supposed to be not discriminating against different ethnicities and backgrounds. So I feel like if we don't have things in their language, how do we know that they really understand?
True. There are some of the forms are in Spanish, translated into Spanish. I can't tell you off the top of my head which ones. But I know what I do if I'm encountering, if one of our agents is encountering, say they have a walk-in or a phone call on a listing, and the party's native language is Spanish or something else. And I am not well versed in that language, say Spanish. I'm not I couldn't talk about a contract to someone in Spanish. Then I find a resource within our firm. We have Hispanic speaking agents. We have some agents who speak Mandarin, I think, Korean. We have a variety of languages spoken within our firm. So I usually would get them involved, give them some kind of compensation for helping out on the transaction, not necessarily a full share, or 50-50, but some reasonable amount of compensation for their assistance in helping with that. So I think that's the best way to handle that. Yeah, and if you don't have anyone up that way, Jennifer, in I don't know about the Ming Tree Group, if we have a Hispanic speaking agent, and I think maybe we do. But I would call them in and say, hey, can you help me with this? And, we'll work out work out the compensation between you and that agent in advance. We don't like surprises. And, but if you don't, then let us know, and we'll get someone remotely to help you with that. Okay.
Okay, great. Thank you. I appreciate that.
Sure. We also have other resources. Sometimes, I like to share our resources within the company. Like we have commercial specialists. Steve is saying Jessica and Malachi are both Hispanic speaking in Eureka. we have a specialist in our brokerage that deals with vineyards and wineries. And almost exclusively. So if you get an inquiry about, I want to buy a vineyard, and you know nothing about vineyards, then, I would call me, and I'll put you in touch with Michael, and, we work out something with Michael. The same with commercial property. If you aren't experienced with commercial, of course, there's a number of agents up in Eureka, including Larry, who know a lot about commercial real estate. But bring those, get the resources within our own organization. We can usually find you someone who has knowledge in an area that maybe you don't. And until you gain proficiency in that area, I would rather have you work with someone, and it would be worth getting, the experience of doing that, and, growing yourself, and your knowledge base, while, you're giving up a little compensation, but it's worth it for your personal growth. And I mean, I see Mary on the call. I don't know anything about mobile homes, yeah, I'm the broker, but if I have a question about mobile homes, I'm gonna call Mary, or one of our agents, other agents who does mobile home sales. Yvonne, works in that area as well. So, call if you've never done a mobile home. Don't go out there and wing it. Get assistance from the resources within our company. Okay. Curtis says, I have a simple pro forma in MS Access for rental properties. Okay, well, send that over, and I'll send it around. Curtis, thank you for that. Okay, any other questions? I'll let you go for the day. Good to see you all. Have a great weekend ahead. We'll catch up with you next week.
All right, bye, Gary.
See you later.
Bye, Gary. Thank you.
Bye, thank you.
This
Everybody
was a
go to-
great one.
Everybody go to the Truck Fest in Ukiah.
It sounds fun.
All right, see you later. Bye.